She walks it loud like a thunderstorm, debunking myths with style and form. True crime, conspiracies, her game. Melissa Jade, remember her name. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Microphone fierce like a roaring lion, unveiling secrets people been hiding. True crime queen of the digital scene, Melissa's got you hooked on her screen. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. From murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. 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 She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame.
Hello, everybody. Hi, Shay.
Hi, Melissa. Hey, everybody.
Hi, Midnight Lace. Thank you so much for 5 months. Midnight Lace says, my happy place. Thank you. Hi, Natasha. I hope you're feeling better. Natasha's sick. Supposed to do Tisha tomorrow night, but no rush. Whenever you're feeling better, sickness just hits you, man. It just comes out of nowhere, you know?
Yeah. And it just I feel like the older you get too, it just takes you out.
You hush now. You don't need to keep reminding us that.
Sorry. Well, for me at least.
Yeah, no, absolutely. Hi, Miss Mogen, and thank you, Just Me, for becoming a member. So I was just talking to Shay behind the scenes. That's why I was late, because I wanted to show her my muffins. That sounds kinky.
It did. That's why I was scared to answer you earlier. I was like, what kind of muffins?
Well, I wasn't talking about that muffin, Shay. I'm talking about my literal muffins.
When you said they were gray, I was like, what?
I'm like, Shay, my muffins are gray. And she's like, no, my literal muffins, I made blueberry muffins. And I squished too many blueberries and added blueberry juice with it. And as soon as I started mixing it, I was like, oh no, because these are the ugliest muffins that you would ever see. But I'm sure they'll take delicious, but they look like violet. You're turning violet, but in blueberry edition.
Don't insult your muffins. I thought they looked great.
They have creams for that. Thank you, Jack. Only muffin tops here at MJ's Coven. See, I don't know what's up with the muffin tops. If you're going for a Dunkin' Donuts, the crystallized sugar blueberry muffin tops, fabulous, delicious. Other than that,
wait. People just sell muffin tops?
Oh, hell yeah. Even at the supermarkets, they just have the muffin tops.
Not in Texas.
Hi, Samantha.
I've never seen that.
I want an equal amount of blueberries in each muffin. An equal amount. They have just blue muffin tops. You didn't know that?
No, I never knew you could do that.
Yeah, just muffin tops.
But I feel sorry for the bottom half.
For the bottom half?
Yeah, what is it? Just trash? You use it for, but I don't know. What is it? bread
That's
pudding or whatever it is.
like saying, oh my goodness, I can't eat munchkins because I feel bad for the regular donut. You
Well,
know what I
it's like,
mean?
well, it's like the people that only eat the donut hole but won't eat
Yeah. I feel
the
bad
donut.
for the outer edges of this donut.
I do not discriminate against muffins or donuts. Okay.
I like the whole thing because each provides a different experience. Like the pizza slice, absolutely amazing. And then when you get to the crust, ooh, it's a different hit. But you have to have the slice first to get to the crust.
Oh my gosh. Gidget, I will have to check that out. I have not seen it. I have a muffin ritual. So if I'll get 2 muffins and I put them in a bowl. You're gonna laugh.
Shay, where are you going with this?
I put cinnamon sugar on top of the muffins, and then I drizzle honey on top, and then I put cinnamon sugar, and then I heat them up for about 30 seconds, and then I go at it.
Oh, okay.
Like it is amazing. I don't know why. Like I have a thing. Like that's how I like my muffins. That's how I make them.
That's how she likes her muffins. Yeah, sure, you can see the muffins. Hold on. Let me
Wow,
show you this
Nikki.
disaster. Hold on. Right hizzer. I have them right hizzer.
They're not bad, guys.
Yeah, they are. Yeah, they are. Hold on. Let me see. Okay.
Shower muffins.
Why is it letting me? Rich, let me share my screen if I want to. Okay.
Refresh.
Look at them. Look at these pitiful.
They do look grayer in this one. I think they look different earlier.
They're looking a little bit more gray. You know why? Because the top is browned a bit. But I cracked this baby open. I'm eating it right now. It's blue. It's blue. But that's okay. It doesn't matter what they look like. I just feel like it was a rookie mistake, and now I know.
Oh my god!
Since I literally pulled over to see these. They're supposed to be the white, like the white with the blueberry blues. Not the whole thing is just gray.
Oh my goodness!
Yes, that's a good idea.
That's right, Kelly. I have used those. That's
but
smart.
do you frosting your muffin? I don't frosting my muffin.
People put cream cheese on their muffins?
No.
What?
No, you kinky motherfuckers. No.
That does sound good, Melissa.
Now you're coming at my peak too. Really?
Avery.
My muffins had perfect peaks. I baked today too. Yours looking a little flat. Well, shit. Aren't you guys a lovely bunch of supporters? Shit, man. Anyway.
This could go so many ways. Hey, Justin.
Oh, man. Hi, Justin.
Actually, cream cheese sounds good. I love cream cheese.
No, I don't want my muffins frosted. I just like a little bit of the crystallized sugar, if anything. I should have added that, but that's really good. Dunk in their crystallized sugar top.
What is it like when they got? I don't know what it is. When I buy them from the store, they have is it a crystallized sugar? It looks more breaded.
Breaded? A breaded muffin?
No, I don't know what it is. Hold on, sorry. There's ducks outside in my pool.
Not cream cheese. Cream cheese frosting like that you'd use with red velvet cupcakes. Thanks, Morel.
See, thank you, Megan.
Take a note from Norel.
Yeah, thank you, Megan. That's what I meant. A crumble coating. Okay.
Are we talking about muffins or muffins? I don't know. Which one are we talking about? I feel like we're talking about muffins with a capital M, but lowercase.
But yours aren't peaked like Avery's. So yours are low.
Thank you, Carolyn Cooper. I love the muffins, MJ. Gray or not? Thank you very much. Hi, Dina C. Okay. All right. So now that we've been distracted enough, we got a lot to get into. Yes, I'm baking muffins in my cottage, Lisa. I guess it sounds cozy, but when you know the reality of what the muffins look like, unpeaked and blue, It's not. It's not.
Seven Lily says they're lopsided.
Yeah. They're lopsided and shit. Whatever. They're fine. They're fine. They'll do the job for now. But I'll make sure to let you guys see when I step it up next time. Oh, you know what? For sure. For sure. I wonder if they need more babies.
Everybody diagnose MJ's muffins and leave them in the comments.
Figure out why they look like so shitty. Oh my god. You guys are funny. But they're like genuinely trying to be nice about it. Like, I wonder if you just needed a little dash of BS, okay? A little dash of baking soda. That's what you're missing. Thanks, Leslie. The epitome of your muffins. Good.
Yeah.
Thank you, Jean. Can you bake Mickey muffins next time? I could do Mickey waffles, aka the waffle maker can do Mickey waffles. So yes, I guess I could muffin it in there, but then it'll be too hard. You know what I mean? They'd cook too fast. You have to get the ooey gooey center.
Hey, mini noodle.
I think your muffins are beautiful and with the capital M in their own way. Hi, Queen of Crew. Okay. Whew. All right. So we're gonna muffin our way out of here. And here's our missing child for tonight's live stream. This is Jaden Hammock. He has been missing since June 17th, 2025, out of Jacksonville, Florida. He is 16 years old. So if you or anyone who knows information on his whereabouts, please contact the Jacksonville Sheriff's Office at 1-904-630-0500. Okay. Yeah, lack of blueberries, I don't think was my issue. But you know what? It's a good point. Oh no, I hope you get some rest, Indigo. But frozen blueberries really are the way to go. I think you guys are right with that. He is very young, Seven Lilies. Okay, it's been since earlier in the week that we've done an Idaho live. And sorry, MJ and domesticated bliss.
Are you talking about last week when we watched a whole hour of the DoorDash driver and then realized, or this week?
Yeah, this week.
And then we realized that what we were looking for was at the very beginning.
Yeah, that's what I meant, Jay.
We got off that live. I told Michael, and he was like, huh. He goes, were you girls even listening? And I was like, shut up.
Dude, we went through hours just for the same thing to be played from the first minute. Well, that's what I did, Surrey, just to let you know. That was honestly like that. I don't think there was any, I mean, unless you really want to get an idea of her overall demeanor and watch her gait and like see what she was like there. Like, I just wanted to hear, I mean, I won't say I'm not happy that I watched it, but I wouldn't have put everyone through watching that if it was really just going to be those few seconds.
I mean, it wasn't a waste of time for me. I would have watched it all anyways. Hey, Wolfie.
Surrey said, that did not look gentle. And she said, to gently fold in the blueberries. And I said, that's what I did. And she said, that did not look gentle. You're right. I totally, like, I fucking mixed that shit. Thank you, Mallory, for 6 months. Okay. I won't talk about the damn muffins anymore, but you guys are funny. So I heard more DoorDash driver footage came out, but I didn't watch it. Did you watch it?
No, I only watched the court thing I told you about. And then my intention of looking for stuff, I took the nap instead.
Yes.
Sorry.
Thank you, Carolina, for 16 months. Always, Melissa Jade. Oh, I thought that was a blueberry, but it's two people hugging in a blueberry color. I love it. Thank you, Carolina. No manhandling the berries, especially if they're blue. That is definitely good advice, Tinker, and I feel like we all need to remember that sometimes. And as we all, I mean me, I need to remember that sometimes.
My mind just went somewhere. Thanks, Tinker. Life lessons.
Yeah, life lessons with Tinker. Okay, so we have like, let me take this off. We have a decent amount that we have to catch up on this site. But I want like because I feel like I saw plunder dropped. Like I said, there was more with the DoorDash driver, but now I feel I got to be very careful because there's a very interesting line that I want to hear, but it may just be in the first second again. And so I don't want to go through all of that. So I feel like we should focus on the documents first and the motions and see what's going on. Because as we all know, there was a hearing, and you want to talk about the hearing since I didn't get to watch it.
Yeah, so there was a open hearing for the motion to continue. That was like 30 minutes this week or this last week. And then they had a closed hearing afterwards. So basically they just did oral arguments that are reflective of what they submitted in documentation to the court. So I was telling Melissa I really wanted to read the documents because basically at the end, what we're understanding is Judge Hippler sounds like he's most likely not going to continue. He told them to keep preparing as if the date is set. So
okay, good. I honestly really could not see him doing it other than for the sole purpose of potentially down the line for appeals. Not preventing it. Yeah.
Yeah, it was really interesting. I wanted to like understand more, but it like I don't know, I think that the prosecution made some good points in their response and oral arguments, and I don't we'll just have to check it out later.
Okay.
It's
let me see. What was the last thing
so the last time we were going over documents was May 22nd.
Oh, all right. Well, then I feel like we should start up and work down because I want to go with the most pertinent, but we're going to do out of I know most is going to be simple ones, but
most of them are 2-pagers. So you literally will probably open them up, then close it back down.
Okay. So then the 22nd.
Yeah. Like a lot of them are like, I clicked through it the other day and I was like, okay, this is going to be short.
Yeah, if it's motion to seal, order sealing, I don't need to go through those because it's just going to be okay. Stipulation to excuse penalty phase.
We might want to look at that one, yeah, because it's stipulation. I don't know what's in it. I agree with you.
This one's 1 page, but it says, okay, prosecuting attorney and the above named defendant by and through his undersigned hereby stipulate to the court excusing witnesses who will only be testifying during the penalty phase of the trial herein from exclusion during the guilt phase under IRE 615. This applies only to contemplated penalty phase witnesses who are not also testifying during the guilt phase. Okay. Easy, simple. Motion to seal exhibits. I cannot believe how close we're getting, guys. We're so close. All right. You want to read it?
Mm-hmm. Comes now the state of Idaho by and through Latah County prosecuting attorney, and hereby moves the court pursuant to Idaho Court Administrative Rule 32 and Idaho Code for an order sealing exhibits S1 and S2 attached to state supplemental rebuttal disclosure regarding penalty phase experts, which was filed on May 27th. Exhibit S1 is a neuropsychology evaluation completed by Dr. Gage. Exhibit S1 contains private medical information, which is exempted from public disclosure pursuant to Idaho Code. Exhibit S2 is a curriculum vitae, which is exempted from public disclosure pursuant to Idaho Code, and like filings have been sealed by this court.
Okay, so that's interesting because that's regarding his like evaluation and assessment and potential diagnosis regarding his probably ASD and any other. I'm curious because yeah, that would be regarding penalty phase. I'm curious what prosecution's gonna get from theirs. You know what I mean?
Right. And I think the only reason why we got to even hear a little bit about some of that reporting was because of some of those motions that were filed earlier on. I didn't expect us to be able to see the meat and potatoes.
Then there's just the defendant's notice of compliance regarding state's exhibits. Okay. Order sealing exhibit. Okay. Motion to seal defendant's amendment 2. Oh, yeah. These aren't worth like even opening up. It's just motion to seal defendant's amended phase 2 mitigation witness list and then granted with the next one. And then motion to seal state's proposed supplemental jury instruction. State leaves the ultimate determination to the court's discretion. Okay, notice of hearing. Oh, nope, that one's June 18th. Hippler. Okay, that's the one we just had.
Yeah, a lot of stuff is sealed. And I expected it because I know that they were working on some of that medical stuff. Which is such a change because we were kind of getting used to like things being a little bit more open, and then now it's like sealed, sealed, sealed.
Yeah, but we're so close. We're so close. I don't think it's that big of an issue. This is just exhibits S1, state's response to the defendant's 23rd supplemental request for discovery. It's supported by a previous stipulation of the parties to seal exhibits which contain facts which have not been made public and would likely impede the ability of the court to find a fair and impartial jury.
Yeah.
Okay.
Where's the motion to continues?
Well, here's the order regarding allocation of reserved media seating. You want to read it?
The court received 2 requests for reserved seating for representatives of the media at trial. Specifically, the court received a letter on May 28th from counsel for a media collection asking, among other things, to ensure that someone from the media is always able to be present at trial, that a seat for a polled media member be reserved. On May 29th, the court received a separate letter from a local AP journalist asking that a polled seat for a member of text media be reserved. The asserted rationale for both requests is a concern that the concert style
Concert style.
Oh, concert, sorry.
But the concert style, okay. Like this is very typical for there to be reserved seating for media, but okay.
Yeah, a ticket reservation system that will be utilized might result in days when no member of the media is allocated a seat. The competing request highlight part of the problem with reserving seats for representatives of the media. Idaho courts do not recognize who or what constitutes media. Indeed, in today's world, there are an unending people and organizations that can make a claim to be a media. In addition to traditional or mainstream broadcast media, there are newspaper writers, radio news media, independent investigative journalists, true crime podcasters, video bloggers, YouTube streamers, Instagram posters, Facebook page writers, and publishers, other social media influencers found on an endless number of internet locations, as well as a plethora of other curators, commenters, and self-publishing journalists. Trying to obtain a consensus on who should be eligible to be a polled representative is impossible. Providing reserved seating for endless representatives of various media types, even assuming those within each category would agree to whom their representative should be, would result in most all the limited available seats being spoken for, such that the interested members of the general public are unable to attend. In addition to the problem of defining the media and getting them to all agree on the designated pooled representative, the request for reserved seating presume a problem that almost certainly will not come to being. Specifically, it seems unlikely that on any given day, every single media member, no matter how defined, fails to win a seat. Nonetheless, the case does have an unusual twist that does not present in most other cases with a lot of media attention. Specifically, the community most impacted by these murders, the citizens of Latah County. Also, the county financially responsible for the cost of trial are unable to easily attend because the case was transferred to a venue hundreds of miles away. Given this, and in part addressing the broader concern for media attendance expressed in the letters to the court, one pooled seat for a member of Latah County local media,
Sorry.
you're fine, of wide circulation will be reserved. The local broadcasters, newspaper, and radio journalists located in Latah and adjacent Nez Perez counties must agree to a local representative to attend each day. It not need be the same person each day, and any local media member utilizing the seat must agree act as a pooled journalist for all media members. The local media must provide a designated list of representatives who will use the seat during the trial to the trial court administrator before the start of the trial. Any person on this list must agree to pull his or her work. The TCA will provide a badge of other documents that must be used to gain admission, together with government issued photo ID to prove the person is on the list of local media provided to the TCA. And that's it. That's interesting on the media. Wow. So
Yeah.
wow. Okay.
What are your thoughts?
Oh, I see people just starting to bitch about that,
Yeah.
wanting to get in.
Well, I get it. Listen, like as long as there's cameras, yes, there has to be media in there because there's going to be a lot that's happening outside of the camera presence. Like even with cameras, there's a lot that we won't see. But I'm also aware that this is one courtroom that is usually someone's being tried maybe with the loss of one life versus 4. And so these are 4 families. So think about how many family members alone are going to be taking up the seats. It's a tough one, because it's going to be very limited. I can imagine it being very limited.
Yeah, I agree. But I do like how they consider the area of where the media derives from. I mean, I don't know if it has to be that specific, but I mean, I'd be honest with you. Like, I would be really sad if I heard like Kevin Fixler couldn't get in. For instance, he's for the Idaho Statesman. He's been covering this since day one. And has stayed on it. He tries to attend every court hearing possible. So for those like in the Idaho area that have that kind of reach and have been engaged, like I do think it would be more fair for them because for like example, Melissa, like when following the retrial, they were doing like this like lottery ticket thing, and I only like was kind of keeping up with like the way that those media seats were being issued. There was many times that like say like Inside Edition, NBC, like News, like Maine, all of them, they would win spots and none of their people would ever show up. And so if then that meant that they had alternates. And so after a certain time of day, like 10 a.m., then anybody who was on the alternate list that waited and checked in downstairs, then they could take one of those people's seats. So it was kind of interesting to see how they did that. But I could also understand the frustration where if you have a lot of people throwing their name in their hat and they're not showing up and, they're kind of relied upon by the public to get a better consensus of what's going on in the courtroom that you're not able to see by camera.
100%. Like we had to rely very heavily during Richard Allen's trial for the few people that were in that room. But I don't like it because you prefer not to rely on someone's perception and interpretation of what they're seeing. But we had to rely on it because that was the only eyes we had in the courtroom.
Exactly. And I realized that the motion to continue, I don't know if we read it, but it was like on May 20th, but I think it's kind of around the same thing. I think we would be okay with starting with the opposition that you have up.
Yeah. So this is the state's opposition to defendant's motion to continue. So I remember reading the defendant's motion to continue. So
we've read a few, haven't we?
I don't remember. Did we read state's opposition?
Not the state's opposition, no, but there's been several motion to continues in some form. But I think we're okay going with the opposition. We already know Anne's gonna say discovery, discovery, discovery.
Discovery, discovery, discovery. So yeah, no, as far as Dylan and Bethany, I believe if they request to not be on camera, that request will be granted. It all comes down to whether or not they request to be on camera, but that's the only two so far that
I heard
he
there's one
has.
more. I think
Oh, did he?
I need to check, but I think Agent Balance as well. I could be wrong.
Really?
Yeah, I thought I saw that somewhere. I may need to, I'll go double check it, but I was like, oh, interesting. Where was that decided on? So don't take that as my word,
Right.
but I saw it like in an actual publication, not just in social media form,
Oh, interesting.
And I was
Okay.
like, interesting. So I didn't know where that came from
All
or
right.
if they
Let's
were
keep
using
that
as
in mind.
examples. So I'll double check. But I was
Yeah.
like, but what that makes me wonder because we didn't get to see Lori's trial, so
Mm-hmm.
Balance wasn't on TV
Right.
because that's
Huh.
where we would know him from.
That's a good point. Yep, you're right. Okay. So I'm sure we'll find out
Yeah.
as we go on though. So this is the state's opposition to Kohberger's team's motion to continue, meaning getting that trial pushed out. So it says, it is time to try this case. And I love the way that they open this motion up. Right there, short, simple, sweet, to the point. It is time to try this case. Kohberger was arrested in late December 2022 and was indicted in May of 2023. He successfully moved to transfer venue to Ada County. In October 2024, this court entered its scheduling order, setting deadlines for pretrial motions and expert disclosures. Kohberger complied with those deadlines without moving for a continuance, including by disclosing 6 expert reports for the penalty phase, disclosing over 2,100 pages of purported mitigation materials, listing 55 penalty phase witnesses, and identifying 132 exhibits he may introduce during the penalty phase of trial. But now, after all discovery deadlines have passed and after the court conducted the pretrial conference, Kohberger seeks a trial continuance of unspecified length. He bases his request on his claim that his mitigation investigation is incomplete. While state is unable to see whether Kohberger's ex parte filing to the court contains specifics, his motion does not. Defendant has not shared what new evidentiary materials he seeks to obtain or how additional investigation will actually produce them. Overall, the record before the court shows that Kohberger's investigation has already plowed the necessary ground. While Kohberger is fully entitled to due process, this court should exercise its broad discretion to deny Kohberger's 11th hour motion. First, Kohberger cannot show good cause or prejudice. Even under the heightened non-binding ABA standards he seeks to impose on the court, his counsel's resources and investigation to date have been adequate, even setting aside that the defense team still has more time to prepare its mitigation case. Moreover, Idaho's constitution also grants the victim the right to a timely disposition of this case. The court should give these victims' rights substantial weight in considering the motion. Finally, while the publicity surrounding this trial is a challenge, Kohberger has not shown and cannot show that continuing this trial will make things any easier. It is just as likely that delay will make it harder to seat a jury. For all these reasons, the court should deny Kohberger's motion. Procedural and factual background states Kohberger was appointed his lead counsel in December of 2022. In March 2023, a second attorney was appointed to represent him. Then in February of this year, a third attorney was appointed to the defense team. The first district public defender has also been participating in the defense. In addition to his lawyers and their staff, Kohberger has 2 experienced investigators and a mitigation specialist working on his behalf. In January 2024, did that boop? Sorry. Oh, it did boop. Okay. That confused me. In January 2024, Kohberger moved for a change of venue from Leda County due to the publicity surrounding the case and the size of Leda County. His motion was granted and the case was moved to Ada County. On October 9, 2024, this court issued the operative scheduling order that contained deadlines for motions, expert disclosures, and pretrial filings. More recently, at the pretrial motions hearing on April 9, 2025, the court advised defendants' counsel to ask for more resources if the defense team needed assistance reviewing discovery. The state does not know if this occurred. Throughout the case, Kohberger has been able to comply with the deadlines in the scheduling order. Pertinent to the instant motion, defendant has made his guilt phase expert disclosures, supplemented his guilt phase expert disclosures, and had disclosed in discovery over 2,500 photos and videos, over 3,500 pages of investigative materials, and many megabytes of electronic data related to the guilt phase. He made his penalty phase expert disclosures and had approximately 21 pages of purported mitigation materials and identified 55 defense witnesses and 132 defense exhibits for potential use during the penalty phase. Kohberger also opposed the state's motion for examination of Kohberger pursuant to Idaho Code and for an extension of time to complete rebuttal penalty phase expert disclosures. At that time, Kohberger did not preview for the state or court that he would seek a trial continuance, and the court denied the state's request for personality testing by its expert, in part because the pending trial date conflicted with the time that would be necessary to explore that issue. I don't think we need to read the legal background because it's just, we know it. Yeah.
Yeah, we'll hear it if you want to watch a piece of the court stuff. They'll bring it up.
So the argument states Kohberger couches his motions in terms of his constitutional rights to due process, to effective assistance of counsel, to an individualized sentencing determination, and to a fair trial in light of intense media coverage. But he has not demonstrated that these rights, which must be evaluated alongside the victim's rights and the overall administration of justice, will be violated if this case proceeds as currently scheduled. For the reasons discussed below, the court should deny this motion. So the court should exercise its discretion to deny Kohberger's motion because he has not shown good cause for a continuance or that he will be prejudiced at trial. So the court should deny Kohberger's motion because he cannot show good cause or potential prejudice. Procedurally, he does not explain why he waited to seek a continuance until after discovery closed, expert disclosure deadlines passed, and the pretrial conference happened, which pause, it's a great point because if you were that far behind, Shay, you would have voiced it earlier, not right now. Are you kidding me? We're right at the heels of trial.
Right. And I think that's why, it's important to note that there's kind of been a bit of a trend that we've seen, right? When it comes to both the motions to continue and the discovery request, because they're parallel and they add together. Remember when Bill was like, every time you've asked for discovery, I've given it. We've been tracking it. We're giving it to you just how we are from the last hearings that we went. And it's kind of layering in here. You know what I mean? Yep.
Cicely, it's August 11th. So we're right around the corner. And this is not the time to get the damn, it's been years. It's not, if you, and Judge Hippler made this aware at one of the last hearings, you had all of the time. Every time I essentially checked in and asked, are we on track? You always said yes. And now all of a sudden you're popping up and you're saying that I haven't even been able to get through discovery. So he's like, get your paralegals, get your legal secretary, get whatever additional assistance you need. And you need to get through this.
Well, and also remember Judge Hippler even asked, why did you take on another death penalty case? And
Yes.
if you need support, why don't we get more support for you? Hippler was offering the defense more assistance and basically said she had to have her eyes on everything. And
yes, she did.
In my opinion, kind of seemed a bit of a control aspect. And I understand how serious this case is, but also there are rights of victims, even though this trial really is centered around Bryan. But there are rights of victims. And I think it is a really important point of having Josh Hurwitz come in, knowing what his history is with victims' rights. And I'm really interested to see how this plays out.
Agreed. Absolutely. So it says substantively, he ignores Idaho Supreme Court death penalty precedent, holding that counsel is not required to investigate a defendant's entire life before he can be tried or sentenced, which is great. Great point. He neither specifies additional areas for investigation nor explains what concrete investigatory steps will bear new fruit at either the guilt phase or the penalty phase. As such, Kohberger's motion amounts to a request for a perpetual continuance so that his counsel can go down every rabbit hole until Kohberger, rather than the court, deems himself ready for trial. The law requires no such thing. The court should deny the motion because Kohberger's team has had the opportunity to prepare and has adequately addressed the issues he claims needs more attention. A defendant's motion is untimely given the procedural posture of this case. The scheduling order granted the parties ample time for trial preparation, and it also set several interim deadlines along the way, including for penalty phase expert disclosures and mitigation disclosures, which is the primary basis for Kohberger's motion. The state also understands that the court set the pretrial conference more than 2 months before trial in order to give the parties sufficient time to prepare for trial after discovery closed and pretrial disclosures and motions practice were completed. If Kohberger was having trouble meeting deadlines, finding experts, or pursuing red flags, he should have sought a discovery extension or trial continuance long before now. He did not do so. Instead, Kohberger retained over a dozen guilt phase experts, 6 penalty phase experts, a mitigation specialist, and has identified over 2,100 pages of purported mitigation materials. And leading up to the pretrial conference, he exchanged witness lists and exhibit lists with the state without stating that he would be moving for a continuance. While Kohberger relies on the death is different mantra and argues that extraordinary measures must be taken to protect his rights, he cites no authority for the proposition that reasonable scheduling orders should not be enforced in death penalty cases. Indeed, Kohberger recently argued that the state improperly delayed in seeking an extension of time for its rebuttal phase expert disclosures. The same principle should apply to him. Kohberger's motion is untimely and weighs in favor of its rejection. You could go.
All right. Defendant's purported need to conduct additional investigation is unsupported and does not establish prejudice warranting a continuance. Kohberger bases his motion on a claim of insufficient resources and the need to conduct more investigation prior to trial, but he has not demonstrated that he is being deprived of anything that he seeks. Thus, Kohberger's claims about the current state of the defense team's preparations are matters of speculation and not the type of demonstrable reality needed to support a continuance based on Kohberger's constitutional rights. 1, Kohberger's legal resources have been more than adequate. Kohberger has 3 trial attorneys, including a lead attorney who has represented him from day 1, 2 investigators, and the assistance of at least 1 additional public defense attorney. He also has engaged an outside mitigation specialist to assist in obtaining materials for use during the penalty phase. This record reflects that this defense team has been working hard for Kohberger and, as explained below, has met the professional standards for the defense of a death penalty case. Yet Kohberger still claims that the court is cutting off his review of discovery. This is unfounded. Kohberger's attorneys have had sufficient time to review discovery and have not established any discovery violations by the state. They have been able to identify over 1,000 exhibits and nearly 200 witnesses for trial. Indeed, the court also recently admonished Kohberger's counsel to seek additional resources from the resource judge if they needed more assistance to review discovery and prepare for trial. Kohberger has not claimed that he sought more resources and was denied. Neither the size of his legal team nor the need to continue to review discovery form a valid basis for a continuance. 2, defendant's expert witnesses witness resources have been more than adequate. Kohberger has been able to retain a large retina of experts, including 6 experts focused on mitigation for the penalty phase. 5 of these experts are mental health professionals. Both a psychologist and a forensic psychiatrist have examined Kohberger on multiple occasions, reviewed his social and medical history, and diagnosed him with autism, OCD, and ADHD.
Yeah. Okay.
Collectively, huh?
Sorry, I said yeah. Okay.
I know, that sounds like, oh man. That sounds like my Joshy poo. He did good in trial. Or
Yeah, you
sorry,
did
did good in
good.
hearing. Sorry. Oh, I'm sorry about that. Um, Collectively, these experts took a deep dive into Kohberger's entire life, including by interviewing his family, teachers, coworkers, and even a psychologist who evaluated Kohberger as a child. The extensive investigations by these experts contradict Kohberger's claim that he needs more time to complete a social history investigation. In the cases he cites, counsel was ineffective for failing to explore mental health conditions or for failing to provide mental health experts with sufficient background information. In contrast, here, Kohberger's mental health experts have had access to a significant amount of people and materials and have created fulsome histories through their own investigation. Kohberger's claim that his team needs to follow up on red flags is also unsubstantiated. In their reports, neither his psychologist nor his forensic psychiatrist indicated they could not render opinions because of unexplored areas. In fact, the forensic psychiatrist concluded that Kohberger showed no signs of other serious psychotic disorders, and at a recent hearing, Kohberger represented that he would not seek to introduce evidence on this unexplored topic. Tellingly, Kohberger did not seek an extension of the penalty phase expert disclosure deadline. Kohberger's claim that more expert testimony is needed is speculative and does not identify what new information would be uncovered by further investigation. This is fatal to Kohberger's motion. So through 3, defendant's counsel investigation into his life story has been more than adequate, and his reliance on the ABA guidelines is misplaced. There is no authority to support Kohberger's desire for more time to conduct a scorch the earth life history
Mm.
investigation. Courts recognize that all cases, including death penalty cases, are constrained by limited time and resources.
Which
I
it's
guess.
so true. I'm sorry, but the way Anne's trying to go about it, and I understand his life is at stake, but realistically, anyone who's going to put up a fit about this, it better apply to all cases in this matter, because you can't just do all the. I'm gonna like she's had years. You can't possibly do every possible thing that has ever happened in his life. It doesn't work like that.
Right. Okay. I am gonna actually read this part of the law. I was just kind of skimming it. Sorry. No, I agree with you. And I assume that probably what I would say they're probably looking at is and they mention it in the court hearing is a retrospective, this like checklist, Melissa.
Mm-hmm.
Okay, so the case law that the prosecution includes says we have never held that counsel has a duty to uncover every aspect of a defendant's past and to present all evidence that might bolster a defendant's mitigation case. Rather, trial counsel's resources are limited, and the strategic decision to emphasize certain aspects of a defendant's background at the expense of investigating others is both reasonable and wholly acceptable. So, faced with this authority, Kohberger turns to a straw man arguments and non-binding guidelines to conjure up alleged prejudice. First, he cites cases where death penalty sentences were overturned because lower courts failed to consider mitigation evidence. But there is no danger of that here. Starting the trial instead of allowing Kohberger to pursue a mitigation investigation with no end in sight does not amount to denying him the right to present a constitutionally adequate mitigation case. In any event, the current issue before the court is a request for a continuance, not the admissibility of mitigation evidence or the performance of counsel. The court's decision remains a matter of discretion. And so then it has a little bit more, it quotes a little bit more case law. So the court will be well within its discretion to bring this case to trial. So that's, again, okay, we can go down. Second, Kohberger relies on the ABA guidelines for the appointment and performance of defense counsel in death penalty proceedings to list all the things that his counsel needs to accomplish. Okay, this is that checklist, Melissa. So this exercise is meritless as a matter of law and fact. As to the law, the Idaho Supreme Court has declined the invitation to adopt these guidelines. And then they quote their case law. So can we scroll down? We're going to go down.
Yeah.
As a factual matter, next paragraph, yeah. Even if the court looks to the AB guidelines, the record reveals that Kohberger's counsel has complied with them. So Table 1 and Table 2 that are going to be attached to the brief cross-reference the list of tasks Kohberger sets forth from the ABA guidelines with the actual record in this case. The results show that an appellate court will be exceedingly hard pressed to rely on the ABA guidelines or any other basis to find that defendant has suffered prejudice if trial proceeds as scheduled. It also shows that extending Kohberger's mitigation investigation will not serve a useful purpose because at this point, any new information counsel hopes to find is biased or mere speculation. So what does that footnote say?
The list.
Okay, yeah, that's fine. All right, let's go down to number 4. Defendant's ex parte filing should not cause the court to grant his motion. Kohberger filed ex parte, an additional document that purports to outline what new evidence he might seek and what strategies or tactics he might use to obtain such evidence. Initially, the court expressed skepticism that Kohberger's motion was properly filed ex parte and ordered Kohberger to provide a redacted copy of this filing to the state for it to address in this response. Kohberger then objected to that order, and the state now understands that the court has decided not to require disclosure of the ex parte filing. That doesn't seem fair.
No, it does not.
How do you expect them to respond? What do you like? You don't know what you don't know.
Right.
Okay, so while the state does not concede that Kohberger has valid grounds for his objection, it will not address the objection given the court's decision. The state, however, does request that if the court has identified a basis in the ex parte filing to grant Kohberger's motion, that the court allow the state to respond to that particular issue. Regardless of the ex parte filing, the court should deny Kohberger's motion because of the resources he has at his disposal and the significant work already done to support his mitigation case. 2. We're going to be moving in now to the Idaho Constitution's Victims' Rights Amendment is another basis to deny the defendant's motion. While Kohberger's reasons for a continuance are unpersuasive, there is another reason to deny this motion. The victims in this case, including the immediate family members of the homicide victims, have a right under the Idaho Constitution and Idaho Code to the timely disposition of this case. Given that it has been nearly 2.5 years since Kohberger's arrest, the victims' rights and their desire for justice weigh in favor proceeding to trial as scheduled. While the term timely disposition is not defined, it must mean that at some point, a trial court can decide that the administration of justice outweighs a defendant's desire to continue preparing his defense. That is one of the purposes of the Idaho Victims' Rights Amendment and is consistent with the Idaho cases requiring a defendant to show actual prejudice in order to successfully challenge a decision to deny a motion to continue. In his motion, Kohberger cites many cases where counsel failed to adequately prepare for trial or sentencing, but he cites no cases where a court that found over 2 years was an inadequate amount of time to prepare, nor could he. He concedes that the Sixth Amendment only means that a defendant is entitled to a reasonable period of time before trial during which counsel might prepare the defense. While he appears to want unlimited time, Kohberger has already had a reasonable amount of time to prepare, as demonstrated by the substantial quantity of evidence his attorneys have amassed against the backdrop, the court can properly rely on the victim's constitutional rights as a basis to deny his motion. 3. Despite intense publicity, the court should exercise its discretion to deny defendant's motion and proceed to trial using its carefully planned jury selection process. There is no doubt that the publicity around this case, including but not limited to a recent Dateline TV show containing non-public evidence, poses challenges for the court and both parties. The state reaffirms its commitment to comply with the court's non-dissemination order, to do everything in its power to prevent leaks, and to assist in determining which person or persons provided non-public information to Dateline. However, Kohberger's reliance on the Dateline episode to support his motion is misplaced for several reasons. First, the question of whether Kohberger can receive a fair trial is not answered by the amount of and nature of pretrial publicity. Rather, it depends on whether a fair and impartial jury can be seated, as the U.S. Supreme Court has said. Accordingly, the Idaho Supreme Court has long recognized that trials can successfully select an impartial jury despite widespread publicity. Okay, we can scroll down. That's case law. So basically, they're talking through how they're able to do that, and so I'll read this part. So with the case law that provides that the court's carefully crafted jury selection process has every chance to produce an impartial jury. Because of the sensitive nature of the court's voir dire procedures, the state will not address the mechanics of jury selection in this public filing. So, guys, if you remember, all of the jury questionnaires have been sealed. I think that's great. We don't need to know that. I want them to find an impartial jury. So, but suffice it to say, if an individual has been so impacted by the Dateline episode or any other publicity that they cannot be impartial, they will not be seated as a juror. Indeed, this case is not the Ada County's judiciary's first experience with a highly publicized trial in recent years. Like the court in the Vallow Daybell trial, this court is well equipped to select a jury, to handle ongoing media coverage, and to conduct a fair trial in the Ada County Courthouse. Second, the Idaho Supreme Court has rejected defendants' theory that a continuance is necessary to allow media coverage to dissipate. So as the court correctly noted at the pretrial conference, delaying this trial will only allow more opportunities for pretrial publicity. There's no reason to think that media coverage in this case will dissipate. So proceeding to trial as scheduled may actually avoid any negative consequences from future publicity. Kohberger's dissipation cases occurred in the 1960s and involved communities where it was presumed and demonstrated that residents had already formed opinions about the case based on local media reports. Here, the venue has already been moved, and the court will use a much larger pool of potential jurors than in Kohberger's cited cases. You can scroll to the bottom, love. I'm right above the conclusion right there. Okay. This case is also proceeding in a highly fractured media landscape that bears little resemblance to what prevailed in the 1960s. What happened in Kohberger's cited cases has no bearing on whether the court can select the sufficient number of impartial jurors in this case. The court should deny Kohberger's motion because he has not shown that the publicity surrounding this case will prevent a fair trial. So in conclusion, for the foregoing reasons, the court should deny the defendant's motion to continue. I don't disagree with that last part. We had a venue
I don't either.
change. I think valid points for common sense for us, you know?
And the question is, how would pushing this out get Bryan more of a fair trial?
Well, I think there actually probably is a good point to the more you push out, the more that's already out in the media, you know?
Right.
Think about Delphi. Let's just put Delphi out there because we didn't even get to watch it. But it felt like it was out there for what, 8 years?
Ooh. Sorry.
You know, it felt like a really long time that people knew a lot about the case, and even things that have been scrubbed from the media. And the longer it was out there, the more people had to developed those opinions, and they still held that trial there in Carroll County. And I can't get over like the fact that like that really, I think, divided a community
Yeah,
and brought them together. As much, sometimes even like I always say, like, as much as you might not believe that the person who is on trial for whatever crime that may be, you could still want justice for the victims. You know, it doesn't have to be so split.
absolutely. Yeah, Tess, exactly. So they have a table here, and they have, right, Kohberger's cited area of inquiry per the ABA guidelines. So his medical history, it's already contained in the defendant's exhibits, addressed in multiple expert reports of mental health professionals. Family members can testify about his medical history, and any missing medical records have been available to Kohberger and can be obtained prior to penalty phase. His complete prenatal, pediatric, and adult health information are contained in exhibits and discovery, addressed in multiple expert reports of mental health professionals. Family members can testify, and any missing can again be obtained prior to penalty phase. Exposure to harmful substances in utero and in the environment. No evidence this is relevant. Substance abuse history contained in defendant's exhibits, addressed in multiple expert reports of mental health professionals. Family members can testify, and any missing medical records can be obtained. Mental health history contained in defense exhibits, 3 of them. Okay. And then addressed in multiple expert reports, and family member and other identified witnesses, including former teacher and evaluating psychologists, can testify about this subject. History of maltreatment and neglect, no evidence. Trauma history, records related to childhood car accident contained in defense exhibits and elsewhere in defendant's discovery.
Oh, interesting. I didn't know he was in a
Yes,
trial.
childhood car accident, but please do tell me how your childhood car accident is going to somehow play a role in this. Honestly, I just don't think so. But so there's that. We have
I mean, unless you had like severe brain injury, I'm trying to think.
severe brain trauma. But then are you going? What are you going to go with? Like, you don't have the NGRI. Like, what would you go with?
Yeah, that's interesting.
Educational history contains in defense exhibits, addressed in multiple expert reports, family members, and other witnesses, including former teachers. We got a lot of former teachers there, and former classmates can testify about this topic. Can be obtained anything additional. Employment and training history. He has limited employment history. Family members and other identified witnesses, including professor he worked for and former coworkers, can testify.
Which
Military.
we've heard those rumors
Yeah.
in the past. That's interesting.
No military experience, and then multi-generational family history, genetic disorders, and vulnerabilities, as well as multi-generational patterns of behavior contained in numerous exhibits for the defense, addressed in multiple expert reports, and family members can testify. Not applicable regarding prior adult and juvenile correctional experience. We have religious, gender, sexual orientation, ethnic, racial, cultural, and community influences. Family members and other identified witnesses, including fellow congregants, acquaintances, friends, and neighbors, can testify about this topic. At least some religious history contained in discovery. Socioeconomic, historical, and political factors contained in defense exhibits, addressed in multiple reports, and family members, fellow congregants, acquaintances, friends, neighbors can testify about this topic.
I'm glad they put these tables together, like, because
yes,
the more that they have started doing this, I feel like the judge is very good. I think this judge knows this case well. He is a smart man, you know? You could tell he keeps up with it, but when you could present it like in that visual form, it's just like boom, 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 like lay it out.
Exactly. And it's much clearer when you have the guidelines to the left and the guidelines to the left and what he already has for it.
How do you know he didn't spend the night in the hospital?
I don't know. So the witnesses that Kohberger wants available per the ABA guidelines. The client's family, extending 3 generations back, and those familiar with the clients, all living family members are subject to the subpoena power. Many have spoken to Kohberger's expert witnesses and are on Kohberger's witness list. We have CE, AK, MEK, MAK, MIK, RK, SK. That's a lot of Kohbergers. The client's friends, teachers, classmates, co-workers, employers, and those who served in the military with the client, as well as others who are familiar with the client's early and current development and functioning medical history, environmental history, mental health history, educational history, employment and training history, military experience, and religious, racial, and cultural experiences and influences upon the client or the client's family. Many individuals falling in these categories have already spoken to Kohberger's expert witnesses and are on Kohberger's witness list. Look at all these names. This is going to be a crazy trial. Social
But this is
service
supposed to be,
Mhm.
and this stuff is supposed to be considered in the mitigation for the death penalty.
Yeah.
So that's what, okay, wow.
You can read the rest, actually. It's a mouthful.
Okay, social service and treatment providers to the client and the client's family members, including doctors, nurses, other medical staff, social workers, and housing or welfare officials. At least one psychologist who evaluated Kohberger as a child has spoken to Kohberger's expert witnesses and is on Kohberger's witness list. Kohberger's medical history also reveals other providers who can be called as witnesses, though it appears Kohberger has not chosen to do so. Witnesses familiar with the client's prior juvenile and criminal justice and correctional experiences, not applicable. Family members can testify about Kohberger's behavior generally. Former and current neighbors of the client and the client's family, community members, and others familiar with the neighborhoods in which the client lived, including the type of housing, the economic status of the community, the availability of employment, and the prevalence of violence. Kohberger's witness list contains neighbors. Family members are best positioned to testify about these topics. Last two. We'll scroll down. Witnesses who can testify about the applicable alternative to a death sentence and or the conditions under which the alternative sentence would be served. He's retained and disclosed an expert witness to testify about this topic. And then lastly, witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. Family members are best positioned to testify about this topic. So that was the state's opposition for the motion to continue.
Stuff. I hope, I'm so happy that they got that, put that together, because that really, and it gives us an idea of what's going to be coming out, and they have a lot of witnesses.
Yeah, so I'm just sorry. I know that there was. Trying to look through what else we got here. Because everything is just seals, motions, orders to seal, motion to seal.
Motion to seal.
Okay, before we go, well, hold on. We have the defendant's reply to the state's opposition. I think the hearing was on June 18th, and this was dated June 16th. So if it's up to you, if you want, we can skim through it. It's 19 pages, or if you want, we can watch the hearing. It looks like they included an appendix in this one. I don't know what the appendix is though. Oh, they're citing sources of circuit cases and how many days it took for them to go to trial. Okay. So that is it's in the news section at the top. The defendant's reply to the state's opposition. It's up to you if you'd rather hear the oral arguments on it. It's going to be kind of the same.
Which do you prefer?
Let's go oral. I mean, we already know kind of the basis of a lot of it. And then we could go through the DoorDash stuff. Because I was opening up and clicking through a lot of these, and most of them are motions to seal. A lot of them have to do with the mitigation and expert stuff. So we don't have access to it. And then obviously the prosecution is opposing some of the alternate suspect stuff, but that's been done in closed hearings, and all we can see on those pages is that they're objecting, and then whatever they're filing with that is being sealed, you know?
Mm-hmm. Okay, let's see.
Do you agree? I think it would be better to use the time.
Yeah. Oh, look at Josh. Okay.
What would be, how am I naughty?
He looks good. He looks ready to go.
Joshy Poo.
All right, this is CR 0124316665, State v. Kohberger. On behalf of the state, we have Mr. Thompson and Mr. Kerwick. And on behalf of, when should note the defendant is present with counsel, Ms. Taylor, Ms. Massoth, and Ms. Barlow. This is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines.
Mm-hmm.
We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized.
Melissa,
This case also faced unique issues.
what do you think Judge Hippler's thinking? He's like, how many times have I heard this?
He's looking like how I'm looking, face on that hand, like, okay, here we go. But the point is that, and I like that the state made sure to mention, they met all their deadlines. And while saying that, it indicates that you're on track with where you've needed to be. Yet verbally now you're saying, oh, no, I'm not. No, I'm not. Yet you've managed to take on a whole other death penalty case. Why'd you take that on if you weren't okay? And she's like, well, I was okay, but then I wasn't. Okay, sure.
Yeah, I know. And I mean, I actually think he's just like, I know like he's like posed like that, but I think he's just, you know, listening. But I find it interesting that like we're right at the wee like the wee hours per se, right? Like whatever, using that term. The jury selection begins in July. If you remember, the state had asked for more time to be able to have their expert witnesses review Kohberger, and then
Right.
the judge was like, "Well, I'll give you a shorter amount of time to deal with that," and it wasn't honored.
Right.
And even the defense said, no, you don't get more time. But now we're over here saying, okay, yeah, now we need more time.
More time.
And we just found alternate perpetrators. And like, but when did some of those people come of notice to you? Was it from discovery that you got 2 years ago?
Yes.
Why are you just now uncovering this?
They didn't have the time, Shay.
I mean, I don't think it has to do with like these are just my personal opinions. I don't see it as he doesn't have ineffective counsel. But it's like I'm kind of looking in, and I have a lot of respect for her, but I'm like, why sit and, throw your arms up in the air about these things when you could solve part of the problem? You're being part of the problem. Like, get help.
I think I love that she's fighting for it.
Yeah, she's doing the right things. I admire her for that.
There's only been 2 times that I've been like, too far, and but she's doing what needs to be done. I don't look at her any less because she's doing it. Actually,
Right.
more so, I have respect for her, but she has nothing. She has nothing.
I think they're at the point where, this is just my opinion, and I don't even know all the evidence, but it just seems like they tried so hard to take the death penalty off the table. And obviously somebody's life is in their hands. I understand that. I don't look at that, and weigh it like it's not important. But it's like, if there was something that they could uncover or had that could exonerate Bryan, they would have had it 2 years ago.
Yes, they would have.
That's just my thoughts. And that's
You
just
would think an innocent man would want to get the fuck out of there. And it's
Right.
been years.
right.
I'm not drinking ranch. I did go for dots and cheese, though. Don't judge me.
Starting
Dots?
with
Like the candy?
media coverage of this high-profile case.
No, Shay. Chat, put her in her place. Not like the candy. Dots like the pretzels.
What?
Shay.
Are you talking about the
can't
flat
call
pretzels?
yourself one of my best friends and not know what Dots pretzels are. Shay.
What?
You don't know what Dots pretzels are?
Oh, the brand, a Target brand. I haven't been around for a few months. I'm sorry, I've had jury duty.
No fucking excuse. Is it a Target brand? I didn't know it was a Target brand.
Oh, is it not? Or no? Shut up, Tess.
Yeah,
Oh my
no,
God,
my
all
chat
of
knows
y'all.
because we've dotted together. I'm basically a sponsor for Dots now.
Oh my God, I'm the worst friend. Okay, Whoopi. Okay. Okay, Whoopi.
The green bag, garlic parmesan, and then you got to get boar's head pepper jack cheese, jalapeno pepper jack cheese, and you got to wrap it around the Dots
Oh my God.
pretzel.
I'm not doing this. No. B Crumbs, Tess, I know y'all have seen me at jury duty with you guys. Have my back. I've been busy. I am ashamed of y'all.
There you go, chat. I love it.
I'm like, really?
You don't understand, Shay. I probably referred people on, like so many people onto these Dots. So for you to come out and say you don't even know what Dots candy? No, not candy and cheese.
I thought the whole time
cheese.
when you were talking about dots, you were talking about candy.
No. What are those big gummy dots? Oh, they're horrible.
Muffy.
You're not alone, Shay.
Uh,
I love a good. I
oh
love
my God.
spelling areas. I love
Thank
a
you,
good
Crumbs.
typo. You're not alone, Shay. I'm gonna use that from now on.
Oh my God. I really thought it was candy when you said it. You said it one time that I heard. I remembered seeing dots, and ever since then it's been imprinted in my head that it was candy. And I was like, how has this bitch never had Dots candy? And I go, but it's MJ. MJ hasn't even watched the Goonies. I mean, come on.
You gotta have it's the green dots though. I mean, they have like honey mustard, they have the original, but mine is the garlic parmesan. Do you hear that, Shay? Do you hear that, Glory?
I heard you
That's
talk
my
about him, but I heard you talk about pretzels one time and Dots. I
Yes.
did not know you were talking about a brand. I have never bought Dots pretzels.
You will, and you'll thank me, and you'll come back for the next Kohberger Live, and you're going to be like, you guys were right. Thank you for the shame. Thank you for the shame, because it is so good.
I really like Gardettos though. Like I like where they have like their honey mustard pretzel things. Like those are really good.
Shay,
What?
Gardettos?
Yes.
I never even heard of that, but no, you got to
Yes, we've talked. This has been talked about before. It's like Chex Mix.
No, Shay, just go get some. You got to order the jumbo bag for $5 off Amazon. Green bag, Dots, pepper jack cheese. It has to be Boar's Head. It has to be the sliced. And then you wrap that baby around and then come talk to me.
Okay, I'm sorry. I feel like the worst friend. I told you. I had told you, did I not? I said I just got over Karen Reed's stuff, and I was like, I'm coming back to you.
You
And
did,
I was,
but like,
I was coming down from a high of a win, and I'm just like,
listen, it put a peak in our friendship.
it did. I was in jury duty. Like, there's times I felt bad. Like, I would really be busy. I couldn't answer Whoopi's called, or I was in jury duty and I can't miss something. Like, I'm just very dedicated once I'm in trial mode.
Just know our friendship took a divot tonight, but it's okay. You could fill that divot with some dots when you get there.
Really thought you were talking about the candy. I just was like, why would Woofy send you that cheap ass candy? Not that it's not good, but it's just like, it's, you know.
Send me my dots. These are my dots. I pre-boxed these dots for the move. Like, do you hear that? That's a seal, Shay. That's a fucking seal, so that my dots keep their freshness.
Okay, what are the pretzels that are flat? I can't remember the brand of them, but I thought those were the pretzels you were eating one time.
No, these are twists, baby. These are twists.
Oh man, the pretzel chips. I thought you were eating pretzel chips.
No. But
Oh my god, I'm the worst friend ever.
Ragu and dots. Shay is 0 for 2.
Let's get it.
It's
The ragu. Okay, let me just explain this.
Go ahead.
Oh.
I'll give you the space. Go ahead.
I will tell you what happened. So apparently the jar of spaghetti sauce that like I had, and I know you don't like jar, but it was whatever. I bought it at Target. It broke. And I called my mom and I was like, I have an emergency. Can you bring me some sauce? She said, sure. She left it on the front porch. My daughter went out to get it, brought it in, and it was ragu. And I was like, this is
Fucking
hilarious. Melissa is going to flip. But I was like, I can't eat this shit without like judging it up.
Yeah,
So-
you gotta judge ragu.
I diced some onions. I sauteed some mushrooms. Then I sauteed the onions. So I had to work with what I had.
How
to make
was it?
It turned out good with adding everything I did, but I would not eat ragu without what I did to it.
You
So.
ragu the ragu?
I made ragu fancy.
All right.
I see them, Woofy. I think they look really good, but I did not realize that's what Melissa was eating. I cinnamon sugar ones. I want cinnamon sugar dots.
I have not trailed off my path of the garlic parmesan, but I'm sure all of them are delicious.
Oh wow! I'm just so
Remember, she puts muffins in a bowl too, specifically, and covers them in honey and sugar. That's right, FOS. No, but honestly, that probably is delicious if you put them in and drizzle them. That sounds yummy.
It is really good. Hey, Harlot.
Harlot, wait, where? I was wondering where you were, and I didn't want to be like a nosy bitch. But hello, you had a migraine. Oh, I hope you're feeling better. All of my mods are sick. I'm so happy to see you. We're not talking dots and shaming Shay. We're not.
I elevated the ragu. Thank you, J13. I had to work with it. I already had the meatballs done. I was like go mode. And I was like, I called my mom. I was like, what is this ragu? You should know better. I even had to talk with her. I said, I'm about to be shamed by my Italian best friend.
Yeah. But I love you still, but we're going to make sure that you have dots in your cabinet, pepper jack in your drawer, and we're going to make sure that we home make sauce from now on.
I like pepper
And you
jack
jar it
cheese.
yourself.
Do what to myself?
You jar it yourself and then freeze it.
I've never made my own sauce, so you'll have to teach me.
We
I
could
told
do
you,
it.
I don't know, like you were shaming your muffins, but I'm like, there's nobody I know that gets home and just talks about like whipping up an elegant dish that I've never even heard of. Like you have mad skills in the kitchen, so give yourself credit.
Made carbonara tonight.
That sounds
And I
good.
told you about the carbonara. It's so easy and it's so good. It was so
But
good.
you made some chicken folded spinach thing we never heard of
Chicken
last night.
romaine yesterday. Yeah, that's
Never heard of that.
It's yummy. It's yummy. And I made
And
ribs
then-
the night before.
And then you and Nanya, like Nanya's over here talking about meal prepping with healthy shit. She like made me feel so bad about
I
my
know.
eating choices. I was like, okay, Nanya, I accept the challenge. I'm gonna start meal prepping.
Like mushrooms, fucking asparagus, like damn, all these vegetables. But my vegetables wilt too quickly. Like they get, you know what I mean? Like you gotta cook them like now. like
Yeah.
Fresh vegetables are annoying that way.
They are. Sorry to derail.
Oh no, that I derailed. My dots derailed, but one day I'll be sponsored and it'll be worth it. There's some sub sitting in the chat right now looking like Hitler, like, can you move on and get to the hearing already? Yes, but you gotta get dots.
I will definitely try some dots.
Yes, the green one.
Non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025.
Anne's
Throughout
hair
the
is
course of the
always on
motions in
point.
limine, and then a motion to strike death based on discovery issues
Oh,
in
it's Anthos.
February and March of this year. The record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast, and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed. And that comes from State versus Creech, 105 Idaho, 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. And effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524 said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase, and they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done.
What have you been doing,
and those have
Ann?
not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated.
Sorry, I'm just pausing. That sounds horrible, Harlot. I hope you're feeling better. Was it like vertigo a bit? That's got to be bad.
Oh no.
Abdominal migraines. It's not crazy, honestly. Like, your head, your brain, especially, like it's the head, literally, it's the head of your whole body, and so that's horrible. I'm really hoping you're feeling better. But with Ann, and that's why I'm so happy they made that chart. Here's the ABA guidelines, right? And no, are you going to have a perfect laid out every single interaction he's had with every teacher throughout his entire, being a pupil? No. But you have a crap ton of witnesses that can attest to each part of the ABA guidelines. Yeah, Jaded, it's an inner ear. Yeah, I don't know. I guess maybe, yeah. I don't know. maybe not vertigo, actually. But I know it can make your whole balance, which then could in turn do the migraines and nauseousness. It's horrible. I hear it. Vertigo is horrible. Yeah, it's terrible. Yeah. But here's the thing. Like, I feel like okay, when she's saying we got discovery even as last week, that means state got that discovery last week. They agreed to send it over as they receive it. And so they're not, and I saw Joshy Poo writing something down the moment she said it. And I'm sure that may be a note that he's making, because if they just received it, they sent it over. So they have the same time that you have.
Well, yeah, I could imagine, like, she's saying it in open court where I just got out discovery, but I haven't looked at it yet. So it's like, well, why not look at her to see when that discovery was obtained? Like, because now it's looking bad against the prosecution again. Like,
right.
I don't know. I think it should be fair for both sides. I love good lawyering. I just think that sometimes it could just be a little bit inflated if you're not fully, disclosing and looking at things yourself,
Right. No way, Carolina. Are you being for real? I had no idea. How'd you find that out? I love Judge Boyce. Okay. Yeah, migraines are very tough.
Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day.
Okay.
The other reason that a continuance is appropriate in this case is based
That's why I wanted
on
to read the
media
motions.
coverage, the dateline.
It was very important to read the motion, but like, to be fair, how much time is an adequate amount of time here? And I'm aware with the massive amount of discovery in this case, I am, but like, you would have realized even when you were midway through, right? Hey, I'm way behind. There's no chance. There's no chance I'm going to be able to, and you would have communicated that. That's not what happened here. It's not what happened. You were on board, on track, all the way until all of a sudden you weren't on track, way too close to the trial. We're at the heels of trial.
Right, but I think you pose a good question is like, how much more time do you need? But also, what do you think that you're missing that's not complete in these files?
I could tell you what she's missing. Something that points away from Bryan. That's what's missing, Shay. Something they can use that, and I know that she's not focusing. She's not focusing. Well, I don't want to say she's not focusing. I think the main point of her attention right now is death penalty. Something she could use that would be in that background, that history of him, that they could use as a mitigating factor.
Well, yes, but in the last hearing, we had, the judge admonished the defense for the allegations that they posed against the prosecution. But I also want to point out that that's also when this alternate perpetrator stuff started coming up. So, yes. I mean, interesting timing.
Very interesting.
I'm going to use the restroom real quick, but I'm still listening.
Unacceptable. I'm kidding. Exactly, Samantha. I think it's more about her knowing as soon as they hit trial, also, it'll go to phase 2, death penalty, if it gets to that place. And I think it's more about she hasn't found her smoking gun yet. And she wants to find something that she could use, which resonates even more with me that he's probably the right guy. He's most likely the right guy.
Is appropriate in this case is based on the media coverage,
Exactly.
the dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger.
No.
That comes from Patton versus Young, 467 U.S. 1020.
No, but listen, Anne, the longer this pushes on, it's not like, oh, the less datelines and the less articles that are going to be published. More. Look, Amazon Prime, July 11th, dropping this series. It's not going to get better. It's only going to get more coverage.
Protect Mr. Kohberger. That comes from Patton versus Young, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime.
There we go.
There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and maybe noted in the book. That is in and of itself.
That's Ethan. I'm sorry, not Ethan. I'm so sorry. That's Hunter, guys. Emily. And, you know, what's her name? I forget her name now. Emily's roommate. There's a lot of people, I'm sure, that are supposed to be testifying. But again, that's not going to get better. Right, Harlot. It makes zero sense to delay because of the media. The trial would just keep getting pushed back forever if they did that because the interest isn't going away. No, it's only increasing now that it's surfacing around the time. It's only going to increase.
Well, I think it's important too. Like, how do you define inside sources? Like,
exactly.
What happened on Dateline, that's legitimate. There's parts of discovery there. I get that. They need to get to the bottom of it. But those words, inside sources, even like you've got emails, you know, Melissa.
Yep.
Like, and you're like, is it real? I don't even know. Like, it's just,
well,
it could be third-party information.
Are inside sources, are they not? So it's kind of like the trick they have in advertising, right? They're allowed to put what is it? Crap, now I'm forgetting it. Like the cheapest coffee that you could find, you know, like, but there's standards of loopholes of how they're able to say that, and it's really not the cheapest cup of coffee, you know, like it's kind of like, all right, yeah, inside sources, yet is it necessarily someone from within the gag order that's speaking out versus no, actually this person's considered an inside source. This person's considered an inside source.
Right. Well, and there's a difference between somebody who is part of the investigation versus somebody who may know family or whatever.
Exactly. Yes, exactly. But it's not going to get better. It's only going to get worse.
And is that information detrimental to Bryan, or is it just about the day of the crime and those people? We don't know, but I wanted to say something earlier and I was on mute because I was closing all the blinds in the house. I always do that it's nighttime. But whenever you were talking about you're like, the media stuff's never gonna end. And I was thinking, you know, with this stuff, it was also around like the scheduling too, where like we've been hearing for, you know, a while, like Anne's needing, you know, more discovery, more this, or pushing the needle a little bit. But I go back to the alibi, Melissa. It started with the alibi because it was like, hey, show me your cards. Show me every bit of discovery you have before I make a finite alibi for Bryan, you know, or not for Bryan, but write this on behalf of Bryan.
Right.
And that's always stuck out in my brain because like I went back and I was reading all those motions and I was like, man, how many times that the prosecution was asking for an information that technically an alibi would have been provided to an investigator and looked at before they were probably arrested. This is a very unique situation. And so like I feel like we're kind of back at that, like, show me everything you have, because I'm trying to find what, like you said, could be something that points the other way. And I think that they tried their best to attack what they could when it came to the tip of the DNA and everything. And when all of that cleared up and they went through the Frank's hearing motions and now the motions in limine, I think they're stuck and they're scrambling. We've already done death penalty, like, and she's doing her job, but it's also, but I really think it's at the court's discretion, because it's a good point to bring up the victim's rights as well.
Yeah.
Like, would anybody ever fully be prepared on a case? Like, I mean, how do you weight that? Like, that's not for us to understand, but I am listening. I want to learn.
She's been moved to civil court. Oh, you're talking about Reed. Okay.
I just find it shocking she took on the other death penalty case, and
Yeah.
this is such a big one. And we're, then she made the comment that she has to look at everything herself, and I'm like, and I have so much respect for you, you're a great attorney, but like, listen to your words.
That's just not possible. And I understand what she's saying. Well, a paralegal wouldn't know necessarily what to look for. Well, if you give 20 hours of footage just to one paralegal, let's just say, and you say, hey, mark down any timestamp where anything comes in view, and then I'll take it from there. Okay, that eliminates a lot of the work, and I understand if there's anything pertinent within those timestamps, you want to look at it, but you need to take on the help. And I feel like that was just an excuse for her not to. She was just trying to buy time.
Yeah. I was thinking too, like maybe an adjacent junior investigator with the paralegal, like they work on that together, like how can you offload some of this so by the time like it's something serious, it's in your plate, you're able to like dissect it and see if it's anything credible to follow up on and find an alternate,
Right. Mm-mm-mm.
An exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
A true harlot. Yes, Cicely, an alternative perpetrator.
Yeah, and they got approval to do some testing on some evidence, maybe linked with that alternate perpetrator. I don't know. Everything's been sealed. So yeah, I mean, of course, there's like they have an alternate perpetrator, but I think they also have to deal with, even if they have that going, they still have Bryan in front of him where his DNA is at the scene, and there's, obviously a lot of evidence we don't know about that the court and the grand jury felt strongly about Bryan being, charged. So this is interesting. I don't know what you would do in that matter. I'm not a defense attorney. I have a lot of respect in like with the legal system, but I can't get over the hump of you have the person that's right in front of you versus the alternate perpetrator.
Right.
Like, are you thinking there's a duo, Anne? Or are you thinking, no, it wasn't Bryan at all? Which I'm assuming that's probably your thoughts because you're defending him. But why did it take so long? When did that evidence develop? And I'm sure the court knows that.
Just recently. You have to remember, she said at that last hearing, she said, I only just recently, going through the tip line, found.
But they've had that information for 2 years. That's my problem.
But it's taken them that long because she's not like, the state who's just picking and choosing. No, I need to go through every single tip. And then through that investigation, did I find something that points to a potential alternate perpetrator?
So then what were her investigators working on the last 2.5 years?
It's a great question, Shay. It's a great question.
Because that would have been, I don't know. I'm just a Monday morning quarterback with no attorney's license. But I guess I was thinking if I were somebody that maybe in that position, I would probably assign one of my investigators to that first, go through every single tip,
Right.
That would have been first things first.
Yeah, absolutely.
Oh. And I feel for that because say Bryan's DNA wasn't at the scene and there wasn't all these other things going on. I think I would feel really differently about it.
Yeah, and you're right, Samantha and Shay. The tip line you would think would be one of the first that they're gonna go through. I don't know.
Yeah, I mean, because that would be where that is the started the investigation in general, like for law enforcement. And if I had a private investigator who most likely is former law enforcement or something to the degree, they would know that that's where to start.
Yep. Yeah, Michelle, it'll be the 3-year anniversary as they're rounding the end of trial.
Jeremy, no, it's been sealed. Everything has been in closed hearings. Like that's why when we were pulling up earlier the court docket, most of everything we saw was sealed minus the motion to continues and the responses. So we don't know anything about who this alternate perpetrator may be.
Hmm.
And I think they should look at everything. I really do. I do.
Of course. No, she's appointed, Callie. She's appointed. He got very lucky, but because also there wasn't a lot of. When I say there wasn't a lot of options, you have to make sure that the defense attorney is death penalty qualified.
Qualified, yeah.
Yeah.
She's death penalty qualified, but if I'm correct, I don't think she's in the DA's office anymore. I think she's in private practice.
Yeah.
And then what we learned was Jay Lodson, who was part of the team. He is still in the DA's office, but he's not going to be at trial. He's there to kind of offer support as needed. So now we have Bika Barlow and is it Ashley or is it Mastis or whatever?
Yeah.
Her, yeah. But Jennings and Bill Nye or whatever, they're not at trial today. Or sorry, not trial. They're not at the hearing today. So we just have Josh and Santa for the prosecution.
But Josh is looking pretty good up there. We needed a fresh young face down there, and he's looking good. His outfit's looking good. Visually, my eye is drawn to him, which is a good thing.
I told you. Okay, I'll shut up now so we can just take in Josh for our first time.
Yeah, come on, Josh. Let's hear it.
Thank you, Your Honor.
Thank you.
I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo.
On the Elmo?
Do I need to hit this button, Your Honor?
You hit
Clerk
it.
needs to switch it over.
Okay, thank you.
Do it. Do it. Do it.
So these are
Keep his
cases that we
glasses.
cited in our brief, and I
He's
wanted
very-
to start my discussion with them. I'll read the top
He's
case,
calm.
which is an Idaho Supreme Court case,
The smooth.
evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence.
Bam.
And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor.
I think she was appointed harlot, but she could have asked for new counsel to be placed on due to the overwhelming amount of workload she had already with Bryan's, and due to that workload, she would have been ineffective counsel for the next client.
Yeah. Well, yeah, I think that person was indigenous. So yeah, it would be paid. But technically, like what I've understood is that there's only a limited amount of death penalty qualified defense attorneys. Also, one attorney may put themselves in the pool to represent indigenous people, and in that aspect, it could be maybe a certain amount of cases per year or hours.
Yep.
However, what I heard on Emily D. Baker, Melissa, and I kind of want to she hasn't gone into full detail, but I'd like to learn more. She said she did some research, and apparently this year they actually changed the way that the attorneys are being paid, the defense attorneys now. And that was why there was kind of a little bit of shuffle back in October whenever they had moved over to Ada County, and they were wondering how they were going to stay on and be paid. So Idaho had voted in a new structure for this. So I don't think this necessarily impacts the Kohberger case, but I am curious what that looks like maybe for them in an appointed aspect later on. But they're going to change the way that they're paying them and appointing them is what I took from her. And she would know best, but I didn't really have a lot of details to fully understand it. So still paid. So there's still, Latah is still funding this trial. I mean, that's why when we were going over the media portion of one of the filings, they specifically were asking for a media representative of Latah or Nez Perce counties to be the person that's the pool media person, because they feel like since they're paying for the trial and it impacts their community, that they should be the voice to be able to get that information out.
Yeah, no, this isn't, I mean, she's using the fact that discovery continues to come in as a potential factor of why she's pushing it out, the overwhelming amount of discovery to begin with, which absolutely that exists. But you have to remember also that they had spoken about in that prior hearing how it is the state aware of any evidence that points away from Kohberger within, let's say, the evidence that the defense isn't aware of, and they said on the record, no, that there isn't. And I believe that. And I understand Anne's argument, though, of, well, what you may consider evidence that points away from my client may not be what I consider that. And I get that, but they agreed as the state received discovery, they would send it directly over in real time to the defense. And that's what they've been doing. So that means that it's the same time that the state received it. It's not unusual that that discovery continues to come in all the way up until maybe even going into trial.
And they're required to, like, even they
Right.
can't say, oh, late discovery. Well, no, it's about when the discovery was received, because you are required legally to, and ethically to keep supplying it even through trial if something comes up. But I do think it was important that they pointed out, remember when we were going through some of those motions, Melissa,
Mhm.
that the defense had like made recommendations that they would like certain software for filing systems
Yes.
of to be used, and the
Yes.
state responded that, we're sending it over in the same format, like you
The
were
same
saying, as soon
format
as
that
we
we
get it.
receive it. Yes, it's
And
not
I,
our job to file it for you and organize it for you, even
because
though
they're,
a lot of it they already did. They had it the same filing that they had.
and yeah, because like you said, like they're the prosecution's going to have to do the organization themselves as well on
Right.
both ends. They just want to make sure it's getting to them timely. But I think also what happened, what we heard was that when the FBI turned over their discovery,
They
they
had
had
the
a more
database.
systematic format, and they
Yes.
liked that. And unfortunately, that's just not something that's in place here. And I can understand that's probably chaotic, but that could be a good job for somebody who is paralegal to get it organized for you.
Yes, that would be the role of the paralegal to do that.
So your
But
right hand person to like
right.
know where everything is.
Yep. Yep. Beat stamp it, have it ready to go so you know exactly what to pull up come trial. And I understand there's an overwhelming amount of discovery, but a good portion of it isn't pertinent to trial.
To
And when I say
trial.
that, we're talking about, okay, you got that like 1,000, and which it's much more than 1,000, but let's just for easy, example, 1,000 hours of footage, and only within a 1 hour time frame is it actually necessary. Like that's the focus, but you obviously need those 1,000 hours. So there's going to be a lot within that, a lot within that discovery that isn't like there's nothing in there, but they still have
Right.
to disclose it.
Or even warrants that they did that may have not been fruitful in information that's pertaining to the case, but they pulled it just because they had to investigate it.
Yep, exactly.
Was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And
This is
with
just
respect to the
mitigation.
ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that
Yeah.
needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues, and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category, and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case,
It is
despite
possible.
the challenges.
Yeah. There's people that don't watch media.
Yes. And that's what I said, Shay, because I understand in our true crime world, for people who follow this, it's like, how have you not heard about Idaho? But because I've done the test trials and I've asked people in my real life, have you heard about Bryan Kohberger? And not even, I just found the other day, Gypsy Rose. Didn't hear anything about Gypsy. You don't know who Gypsy Rose is? You know, like, and I realized for us, it's crazy. But for the good portion of the population, it's really not that hard. You're more limited depending on where you are, obviously, but it's not out of their own possibility to find an unbiased jury, a fair jury.
Well,
yeah, and we're allowed to know about the crime. The same way there was a juror for Valo's case. His wife very much followed Valo's case. He didn't. He heard of her. He knew the basics, and he was allowed to be the juror.
it's a, can you be impartial? Yeah.
Yes.
And I think those voir dire questions, because, you know, they're both the defense and the prosecution are going to be researching potential jurors' social media, etc., during this voir dire process in selection.
Yes.
The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place, if there's a continuance. What seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that, you know, this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said, we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach.
And that's why she needs to keep digging, Shay, because there's nothing within it that can be used. No slam dunk. That's the problem here.
I know, and as I was like, I told you I watched this already, and I really liked how Joshua was kind of smooth in his delivery, because when we got to even read the motions, it was like, interesting. He's pointing out the things that aren't being said.
Okay. Yeah, it's very obvious that the problem is that she has not obtained what she's looking to obtain.
Yep.
For lack of investigation. So I think that is sort of proof in the pudding. We have life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on.
So Anne did not open up that discovery. It made it look like they're being delayed a discovery.
Yep, exactly.
What? That's what I was like, why? Like, Anne, like that kind of made me a little irritable, because I just like, Anne, come on.
Again, hi Kevin. It's from she's looking for something very specific and she has not obtained it yet.
But to throw shade, I just received discovery.
I just received
And I haven't even opened it. Like, you're trying to use that to emphasize your argument, yet you didn't even open it. And come to find out, it's a response to your own witnesses.
Mm-hmm. Exactly.
That's natural. I'm not trying to hate on you. I love good.
I know.
So with that, Your Honor, I would
hate
again
when
rest.
that happens and I can't just pause it. No hate on Anne. Listen, she can only do so much within her power. You know, like it's not like she could all of a sudden make a guilty person innocent. She's limited.
Thanks, Muffy. Yeah, no, I agree, and it's like I really respect good lawyering, and I think that there's been a few times where because I have a lot of respect for Anne, that like it's just missed the mark for me, and the prosecution has done that as well. I'm not gonna lie, they've had points too, but today I'm like, we're kind of at the finish line. You know, people are watching this hearing. You know that they're interested in this. This is a big deal. The motion to continue right at the time where you have families that have probably already booked Airbnbs, right? Planning for this trial. Like, this is kind of inflated emotions, like, for people, I would suspect. Don't you agree?
Yeah.
And like, come and be accurate, be precise in what you're arguing. Santa's always here, Gidget. We love Santa.
Yeah, Santa's the prosecutor. He's always there.
Bill's been with Latah for many, many years. And actually, he was the one that we were mentioning that it said that I found an article that the DoorDash driver and her husband's homicide, he was the prosecutor in that case.
Yeah, that was an interesting nugget.
Yeah.
Very interesting nugget.
But now it makes sense why Josh got up to speak, because he thought they were going to be talking about the mitigation stuff, because he was the one that was filing for the mental health mitigation and going through that.
Yes.
Statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorch the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
Any reply?
Yes, thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records, Bryan Kohberger, past treatment records of Bryan Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses.
Well, sorry, but you can
Access.
sorry, hold on. If they're refusing to speak to you now, they're going to refuse to speak to you tomorrow too. You know, you can subpoena them under court order, but like, what is, if Shay is refusing to speak to me today, what is an extension going to do? You know?
Right. And I'm wondering what is the weight of what information that she's expecting them to provide, you know? Like, could it just be like there's a few doctors that saw him and they're just like, we don't want to speak, we don't want to be part of this? Like, I don't know. And I could also see too that, like, especially with how we have, I don't know, this culture that's developed around some of these trials where people go at these expert witnesses and just dissect their lives, et cetera, et cetera. Like, if I had known somebody like, I don't know, 20 years ago, and I really don't have much to say, I might not really want to be involved in it unless I'm subpoenaed. Like, what is the weight of that information, you know?
Right.
That's what I go back to. So when he was saying, like, what are the red flags? What are you expecting? What is the date that you're seeking for a continuance? Like, it just seems like they're asking but not being specific. So it's just it seems like an illusion, you know, to the prosecution and to the court. Like, I think that they need to weight it better to maybe have it taken a little bit more seriously by both parties, you know?
Yes.
To additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court.
In federal court.
Which moves at a snail's pace in its best day in regular
Oh.
cases.
Oh, it's not federal.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But
Then
what
why
I
did you
can
bring it
tell
up?
you is that a capital case where we have a client and we need
Like,
to
why are you comparing
investigate
apples to
both the
oranges?
merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do.
2.5 years.
2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information, and
Yeah, Ann Taylor apparently makes $200 an hour, Harlot. And if you are expected to work a standard 40-hour work week, it equates to about $8,000 per week. So
A lot of money.
yeah, any overtime is also billed at the same rate of $200 an hour.
They're spending a lot of money. That's like on this case.
But so I think what's it called? Fox News showed substantial charges over months with the billing records for
I want to watch that.
$24,997, $27,799, and then even $38,272. I'll link it here.
Yeah, I want to check that out.
Okay, hold on. Let me grab the link.
I mean, I know I've seen the stuff that was it like last year when the interview room, whenever they went over some of the funding, remember that the University of Idaho got and the state provided them, and the way that money was being tracked as allocated. But I've been really curious of what it looks like from the legal side. Because the state overall has expensed a lot for the victims and their loss of lives to be brought to justice, and also for due diligence of Bryan's, rights and fair trial.
Yes.
And there's this other stuff that's out there that's a red flag, that's real, that you need to investigate. Your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
Thank you, Melissa. I do think that they've been very zealous advocates for Bryan. I really feel that way.
Yeah, they've been.
I mean, I've been impressed. I know there may be things where whoa, but you got somebody's life on your line.
I'll take the matter under.
No. And you know what, to be fair, Harlot, I don't when I read that, I'm like, okay, 40 hours a week, but is it 40 hours a week if she's doing 2 cases? I know standard lawyers do work a lot more than 48 hours a week. So I'm not sure how it gets divided. And maybe it's within one of those articles. Let me know if someone finds that, but I'm not sure how that works.
I'm sure they have to log their time for each case.
Oh yeah, they'll have to have adequate records. But there's a lot of money that goes out, but that's not taken out of Ann's end of it.
Right. Not to,
versus if she was privately obtained, she would have to front, and then it would, I don't know. Actually, I don't know with like something like this. I'm not
when
sure
they get,
how that works.
yeah, I mean, they're paying for the other lawyers, the investigators, they're paying for the
Yes.
mitigation specialists, the experts, and there's a lot going into it.
Right.
On top of all of the prosecution and the local government and LE and everything that's been put into this investigation to bring this to trial. Crazy.
For advisement and get an opinion out in short order. In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated.
Um,
All right. Is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
Your Honor, I don't believe so.
All right. We'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
That's it. I think he kind of tells you right there where he's leaning. So
Yes.
he hasn't issued an order that I saw as of yet. I know that there's been a couple more filings on the docket. I haven't opened them up yet. I know one was the delay. It was the response to the defense response to the state's opposition, but that was on the 16th. This hearing was on the 18th. So we already kind of got the sum of that. I'm just shocked though. Like, it's like, I hear what the prosecution is saying, and I understand where Anne's like, you don't know what you don't know, but what are they even looking for? What do they feel like they don't have? I can't get past that. And you made a good point, Melissa. It's they're looking at something that exonerates them, and I get that. But if the facts aren't there, then then you just have to kind of go through the procedural things and go reasonable doubt.
Yes. August 11th is when it's supposed to start, Kimmy. But exactly like you said, she's looking for something she could use, and I think that it really shows. Oof. It's that hard. It's that hard to even. And I want to point out that, because everyone on the internet thinks they know this case the best and they could try it better than Anne. I know you could use this and this and this. The standards you have to meet in the court of law, get the hell out of here. But she's struggling. I think she wants to go in with a smoking gun. I'm not saying that she's not going to have little things here or there that could make you go, I think she will. But I think she knows she's going to need a lot more than that.
I think this is just my opinion on the matter. Is I think that what presents to be probably the biggest issues is for Anne, and challenges with the team is, even though it is all circumstantial, is going to be the DNA and both the digital the digital and technological evidence that they have, like digital evidence that they have. You know what I mean? That's a bit of a booger. I think that there was, from what we understood, and I'm only just thinking about from what we read, of some of the expert witnesses that the prosecution is bringing in, that they've had some forensic auditors that have looked at Bryan's accounts, and they are going to be testifying on habits of behavior. I remember how they said that right before, I guess, the crime was committed, allegedly, obviously, we haven't seen all the evidence, but that he had tried to use some software to erase, forensic software to erase data in his computer and things like that. I think that there's probably a lot of things that are going to seem suspect to jurors, maybe actions taken by Bryan that necessarily don't say he did this, but why are you doing all this, you know? And I think that's hard for her to fight up against.
Listen, I admire how hard she's working, but at a certain point, and like you spoke about earlier, the victims have rights too. And yeah, absolutely, Bryan has a right to a fair trial, but how much longer would you need? And the fact that she couldn't go in there and say, hey, I need 6 more weeks, I need 3 more months, 6 months, like you weren't even able to put a number on how much additional time you needed. That's a problem. And is this going to get worse, or is this going to get better in regards to media? It's not going to get better. So what? And if people are not willing to talk to you, is that going to get better? You're just searching and searching and searching for something that I genuinely cannot believe time is going to resolve.
Well, and then you also have to consider too, Melissa, you have to be reasonable in the time that, respecting Sixth Amendment constitutional rights of the defendant, but the longer you do wait, you do run the risk and potential of maybe some of those expert witnesses or other witnesses may not be available. Maybe they pass away, maybe certain things happen, or evidence gets lost. Like, God forbid that ever happen at this point. But I'm just thinking of things like that. Like, whether you're young or old, anything can happen. We're never promised tomorrow. And doesn't mean and I think this is what is also killing me was that they were. Do you not remember back whenever Anne had filed a motion the first year? It was like Bryan didn't give up his rights to a speedy trial, and then it was kind of like, well, he already did. And it's like I feel like we keep playing ping pong here. Like I can't quite understand what we're fighting for and what we're fighting against. Sometimes it's defense. It's what works best in which argument, and that bothers me. I need something to be consistent because that helps me follow your case better. You know what I mean? Because it's like the double-edged sword. It was like I think that's what Joshua Hurwitz was kind of explaining. It was like, no, hello, we were asking for a continuance because we needed a mental health expert, and you said absolutely not, state. But then you turn around a couple days later and you file a motion to continue. Like, I mean, I don't understand it. It's not consistent for me,
Right.
and I have a problem with the consistency because that loses credibility for me.
Yeah.
And maybe I'm looking at it from a holistic overall perspective and not just looking at the issue at hand, but that just kind of bothers me.
Well,
or am I being too much? You know what I mean?
No, I'm just happy that I'm happy that we're away from Judge, and I really like Hippler, and I'm happy that he's like full steam ahead. And I don't think he's doing that while being unfair at all to Bryan. I think if there was a legitimate reason, he would. But I think he see that this is all tactics, and I don't blame Anne versus no, it's time. The same way that state responded to their motion, it is time for this to go to trial.
Yeah.
And
I mean,
what that would do to the victims' families, this is no joke. This is at least 3 months, no definitive end date. Anything can happen. You have to take off work, take off school, whatever is your circumstances financially, reserve Airbnbs, hotels for that entirety period of time. That's all been done, and pushing it off, unless there's a damn good reason.
Yeah.
Right? We love Hippler. He is good. I like him, and I'm really excited to see how he's going to handle this courtroom once it starts going. I can't express how ready I am for this trial to happen. Like, I am ready. I am here for it. Like, to have so many of the same people who are here from day one of this coverage to be here now. Because do you remember when it got he waived his right for a speedy trial from that October, and it was like, oh my God. And here we are, and it's happening a little over a month away.
Yeah. I mean, I feel like it's palpable at this point. This is just, this is just the case I've been waiting for forever. And like I was really, I was so happy when we got to see justice for Quentin Simon. We've talked about this. Like, was really looking forward to that. And I've always said Delphi next. And then I had followed Karen Reed, and that was aside from you and I. I know that's not one you've really followed, but this one is like, there's something about it you're drawn to. And I think everybody gets drawn to certain cases. And if they wonder why the media is covering it, is people connect to this. It's hellacious. It's wild. It's the worst nightmare you can imagine, sending your child off to school and something horrendous like this happening. Or for those that aren't old enough to have kids or don't have kids, they may have been that person that thinking back in college, how frightening this is. And it captivated the world, and everyone is watching. And it doesn't, I don't think it's ever going to stop. I mean, people still watch Daybell Vallow, I mean, like,
Yeah.
and they still are watching it through all the different trials that she's had. There's some that just capture or captivate media, and depending on how widespread that goes, whether it's national, international, they'll follow through. And for those journalists that are dedicated into reporting on it, they'll keep the followers and keep people going. So I don't think it'll ever stop. And I think you're right, Melissa. If they take maybe more time, it could be worse for them. Like, why
Yeah.
not get ahead of it? Because we don't need any leaks. Not that there should be any more, but that evidence needs to be sacrosanct and be presented to the jury, sorry, and not tainted.
I'm like, I get chills thinking about trial starting, and I don't know if that's the right way, because I don't want it to be misinterpreted, versus I'm so eager to see justice play out. I'm so eager to see the evidence, the answers that so many of us have pondered upon for years, let alone the families. But to also see how the arguments are going to be made, I'm very excited for that. I'm very excited because we've seen it happen in front of us with news outlets or YouTubers or even amongst friends. You're taking the little evidence that we've had and you debate it, and to see it actually play out in the courtroom, like, I'm excited for the legal aspect of it. And I'm just, what haven't we known? Because this has been shrouded in secrecy from the beginning. And so to finally be able to get those answers and get an understanding of what happened, to be able to understand, is this the right guy? I cannot wait. I just really cannot wait.
Yeah, I agree. Oh, speaking just of things that were going on, because I told you I would look, but I think Idaho is kind of waiting for this, like, just what I can tell from like the social media stuff. They're, of course, still talking about the DoorDash stuff. But other than that, they were talking about the motion to continue in hearing this week, and that also, I believe, remember how we discussed that, like, Xana's mom is getting some help at a facility or something, that like I had heard through like third party that was talking to her. I think she's out, and like, I guess now news media sources kind of have picked up, and we're spreading awareness because they were trying to raise money to get her to go to the trial. So that's the only thing else I've kind of seen outside of the norms that we've seen, but we've already kind of been down that rabbit hole with the Kara stuff. I doubt we want to go in that.
Right.
But I did see that, just in essence, not just focusing on Xana's mom, but, in whole, like you said, these families are planning to be there, and some of them have large families that want to be together. And there's going to be parts of this, like, trial that I'm sure there's days that they may not be able to attend, depending on what may be presented. I don't know, but I wish them all luck. I hope that the judge, makes a sound decision to protect the case, protect Bryan, because I personally say Bryan is the guy, and a decision's made that could put him up for appellate and he get out, like, and he really is the person, I would be pissed.
Absolutely. You know what, Wolfie, I don't even know. Like, I followed Suzanne Morphew.
Oh yes, I watched this.
Yeah. And I'm not surprised. Well, in a weird way, I was a little bit surprised. I figured it was coming, but like, they had to it's not as easy as you think to bring all that evidence again and have enough to charge him again. And so I'm happy, and I just hope that this one sticks. I hope that one sticks, but
So they're gonna be. I did catch up on this. So Melissa, when it first came out that night, I needed a
I'm
break.
listening. I'm just gonna run to the restroom while you talk.
Yeah, go for it. I'll tell you. So everyone knows, obviously, when they first tried to bring the case against Barry, there was prosecutorial misconduct, and those charges were dropped. However, where Suzanne's body was found is a different district than originally where Barry was charged the first time. So they brought the charges out of the district that Suzanne's body was exhumed. And when they did testing in her bone marrow, when they did the testing in her bone marrow, they found that there was the chemicals that used to make the chemicals that they use for the tranquilizer gun when they're whatever that is. I'm sorry, the words aren't coming to me, guys. It was a specific prescription. Okay, guys, it was a specific prescription that what. Thank you, thanks, Wolfie. Tranquilizer stuff. Um, it was a prescription that was addressed to him. Yes, thank you. The banned chemicals, the chemicals. And those chemicals were in Suzanne's bone marrow, so that's huge. I'm curious how that's like weighted, but that's part of going to be the additional evidence that they were able to bring in the second charge, to the first, because they have Suzanne's body. But like I said, it's going to be charged in the second district. And I only got to watch a couple local media outlets the night that they had Barry. They had Barry indicted, or taken in, but he's actually was taken into Arizona. So they're going to have an extradition hearing and him be brought from Arizona to Colorado. And I've followed that case for so long. I'm praying for Suzanne and Barry's daughters because they have stood by their dad's side. And I know that was a really hard time for Suzanne's family too, because they had been, her brother and sister have been zealous advocates of trying to find her remains and find justice for her. And this is just my opinion. I think Barry's a narcissist, and I think he manipulated his kids, and like it kind of like caused this divide. And they were convinced their dad had nothing to do with it. So I don't know how they're doing, but I'm praying for them because this is the second time. I actually think that this is stronger. I'm glad they're doing this out of another district, Melissa.
Yeah.
But that bone marrow and the BAM chemicals that Tess helped me out with, thank you. He's the only person in 5 states that bought those chemicals. Thank you. I think that's very, very damning. But
that is 100%.
it is. It was a big thing because Melissa, you and I actually talked about it when they first found her body. Remember?
Yeah, I remember.
I was like, wow.
Yeah.
Okay, sorry. I'll quit my going on and on. I just, me, I get into my true crime.
Suzanne Morphew and Barry Morphew being charged again, Coffee and Skeletons. And I remember even this was years ago, like back finding out, he stayed at a hotel and then it smelled like chlorine, but the pool at the hotel was closed and all of this stuff, like it was crazy.
Yeah. It's Barry Morphew it's Barry Morphew. Sorry. She's like, what case is being talked about?
Yes.
Sorry, Coffee and Skeletons. I just went on a rant because it was just really exciting because a lot of people felt let down with the prosecutorial misconduct, that there may not be justice for Suzanne, and there was no body at the time. And then when they found her body, they were like, are they ever going to charge Barry again? And how will they do it after this prosecutorial misconduct shit? So I think that I'm hoping, and it seems like they're going the most strategic route to get a conviction. So you want to chase? Oh my gosh, not the Diddy stuff. So wrong.
Hold on.
I haven't really been following all the Diddy stuff. I'll just be honest with y'all. That's something that like I'll read about it every now and then, but that's some heavy, heavy stuff. And I know that they don't have like cameras in the courtroom, so you have to be able again to kind of follow up through people that are there taking notes.
What is it called? They found her while looking for someone else, so I'm sure Barry was so shocked. Yeah.
Yeah, they found two other people.
Yeah.
And I've actually wondered, Melissa, was her body moved there?
A good possibility.
Yeah.
It is hard. Yeah, so there's that. Even with Lori, just even the audio, it wasn't the same. But to be fair, that was at the same time of Letitia, and I was so invested in Letitia. But no, because even if it wasn't, it's still not the same. I'm a visual person. I need to be able to see what's going on.
But surprisingly, you and I both, Melissa, we actually did try to keep up with who was covering the Delphi stuff because we wanted to know.
Because that was, well, I don't want to say it like that was, I don't know, like that was just so, what was being relayed was so, you know, like, wait, what's happening? You know, like, it was very, I feel like with Lori, there was no doubt they were the cause of those children's death and Tammy, but like with Richard, it was a hot topic. So that would be kind of like Idaho not having cameras with Kohberger.
Well, don't you find it interesting that there's some cases that have like polarizing sides of whether they believe that the defendant is guilty or not? And there's some that like people just don't even like rebut. They're just like, that crazy bitch did it.
Yep. Yeah, absolutely. I thought I heard about it had been moved because there wasn't the same amount of decomp or something. It's very interesting how they're able to determine where a body was and how it'd been moved and stuff from the decomp process. I love when medical examiners explain because it's things that you wouldn't even think about. Yeah.
We watched a few like specials on it because Michael hadn't heard of Suzanne Morphew.
Yeah.
And I was like, really? And I was like, but maybe for me being a mom, knowing she went missing on Mother's Day, like it just, there was so much about it that resonated. We got done watching it and Michael was like, that was wild. I have never heard of a case about so many animals. Because you got, you know, the amount of animals that get brought into this. Like, remember there was a mountain lion or something. Like, he had like all of these different animals that were part of this story.
You cut out. Please do, Wolfie. Shame, baby, come back. You can go on me. Sorry, I was just being like, I got distracted because I was being yelled at by people in phone calls from prisons comments for offering. Because like I get tagged by phone calls from prison whenever they use a photo. And so I looked for their email so that they could use the batches without dealing with watermarks. And so I couldn't find an email. So I just left a comment and I said, because, you know, you get notified. I'm like, I'll send you the batches of the original so you don't have to have the stupid watermark across the face. Just let me know. And I'm being attacked in that. I'm being attacked in that damn comment section for simply offering. And they're like, phone calls from prison isn't like that. They don't do drama. Da-da-da-da-da. And I'm like, it was just an offer. It was just, hey, if you want them, use them, you know, like hit me up, email me. And it was like, well, it's not their thing. Really? Because she's using them, you know, like I only commented because she's using them. So don't say that's not their thing. But it's amazing how just simply offering to be nice and say, hey, if you want all the originals, that way you don't have to like kind of thumb through my live and find one that works. No problem. You know, like that. I'm just people.
Was it like subs, like trying to start the drama?
So multiple of them, which I'm like, where is this coming from? Like, you're yelling at me saying it's not her thing, yet she's using them. Hence why I'm offering. It's not like I'm just going over there. Like every time a creator tags you to give you credit, you get notified, So like, hey, Phone Calls from Prison tagged you. So I saw the notification. I clicked it. Hey, if you ever want the originals, because it sucks when you have the water. And I've offered that to many creators. It sucks when you have the watermark. I know it messes up like the whole thumbnail and stuff. So it was just created a creator etiquette versus damn, like what's your guys' problems? Like, and I'm telling you this as a creator, don't speak for creators, especially to another creator. Like, because you're making drama for them. Meanwhile, they may have just been like, that's really nice. Thank you. Like, you don't need to speak on behalf of the creator. No matter how close you feel to them, don't speak for them.
Oh yeah, I would never speak for you. You got your own voice. I think that also kind of deflates the other person, It's not cool.
But Gidget, here's the thing. I looked. If you go to Phone Calls from Prison and go to their about section, I looked for the email. There was no, like, that's the funny part is I looked first. I don't like leaving comments because I hate anything that like brings attention to your channel. I think that's wrong, and I don't like to do that. But if there's no email available, all I could do is leave a comment. That's all I could do. But I was trying to be nice.
It's so funny. Like one comment, like the tone gets totally misconstrued and the point.
It was to be nice, but I think it's ridiculous that they're yelling at me saying, why would they want those photos? As the photos are in the thumbnails, you dumbass. Like, I'm only saying that because they're being used. So I don't want the need for your thumbnail to have my name on it. That's not cool, right? Wouldn't it be nice just to have your thumbnail without my name on it? I wouldn't want my thumbnail with someone else, like another creator's name on it,
Well,
but
and that
sorry, like shit.
But that just goes to say that they must not watch you because you've said that to other creators. Like, do you want me to just send you it so you can use it? Like, you were always open to that, and it's not ever rude.
It was, but that's why I'm like, really, if I want to be petty, I could get mad at that. I'm not going to, because that's not Phone Calls from Prison's fault at all. They're amazing. They always credit. They're always nice, like.
Yeah.
But that's why it's like, don't speak for creators. That's not your place to come at me as another creator in the chat trying to do something nice. And then what if I wanted to be petty and turn around and get mad? Like, what are you doing? You're causing drama while saying I do the drama. Okay, whatever. No problem.
Look in the mirror.
Yeah, I don't know. Like, that's what you get for offering, but whatever. Like, it's just amazing. I'm like, why does my phone keep going off? It's notification from this damn comment. Your drama. Don't bring that drama here. Bitch, you're the one bringing the drama. Like, just what? I don't know. But all right. So if you want to pick a day this week, and I don't know what else is going to happen, but I definitely want to at least peer out this new DoorDash body camera because it looks a lot clearer, Shay. Like, we could actually see her. We could actually hear her. And I don't know anything else about it, though, other than I think it may be a separate incident. But if she's talking about it during numerous instances, that's interesting to me.
Yeah, I'd love that. Let's see what happens on the docket tomorrow, and maybe we could coincide it with the judge's orders so we can make the most of the time. And I'm really hoping we get an order from Judge Hippler.
I think that we will. Yeah, I think he'll probably have it posted tomorrow.
Yeah, I do too. But thank you for having me. I hope you have a good night.
Yes, guys. And I'll see you guys tomorrow for Members Only Monday. I'm doing part 2 with Natasha for the social media post. Oh, no, I didn't. I hate when she leaves early. I want to leave with her. But we're going to do part 2 to Letitia Stout for Members Only Monday social media post. And then me and Shay will talk. If the next thing is posted, maybe we'll do Tuesday, Idaho. Figure it out, obviously. But thank you all for hanging out. I hope you all have an amazing rest of your night. Thank you, FOS. MJ, I know it's off topic, but do you know what state Harvard is in? Can I cheat? Oh, you're a dick. Oh, you're a dick. You know what? That's a good one. You nearly got me. You nearly got me. That was one fucking day. I'm gonna slip. But that was a smart way to go about that. Thank you, but I deny your super chat. It's just across the river from Boston. How about that? Yeah, I got that now, so there's that, but I didn't know the answer, so it took that word popping up for me to realize, oh no. Yeah, that's the word. It's the main campus is in Cambridge, just across the river from Boston. There you go. All right, guys, I will see you guys tomorrow. Good night.